everyone. I've just gotten the go on our panel session this afternoon in Hong Kong, evening in Australia, where I am at. So we will be talking about pedagogy, very much focused on outcomes-based learning. We will have presentations by Professor Daniel Pascoe, Ms. Jenny Chen, and I will do the last presentation, which means that if we're running slightly out of time, I will just have to shorten mine. I would like to remind everyone of a few housekeeping rules. First of all, well, you can see them on the screen. Each presenter has 15 minutes to give their presentation, and then there will be 5 minutes for questions and answers. Now, if you have a question, could you please send that to me in the chat? So if you send me a private chat message with your question, then I can relay those questions to the speakers afterwards. For everyone who's participating in this session, please keep your microphones on mute. And also, if possible, turn off your video because that might have issues for the connection. So going to our first speaker today, Professor Daniel Pascoe, who's on the screen now. Could you unmute your microphone, Daniel? Thank you.
Okay, sure. Can you hear me now?
Yeah, we can hear you. Professor Daniel Pascoe is an associate professor at the City University of Hong Kong School of Law. He just got his promotion, so congratulations. Great work. He works in the area of criminal law. Looks predominantly at the death penalty. And last year he published his monograph, and that is called Last Chance for Life: Clemency in Southeast Asian Death Penalty Cases. Now, in addition to criminal law, Professor Pascoe also has a real interest in legal education and was in fact one of the participants of the very first conference on directions in legal education in 2016. And in his presentation today, he's going to combine those interests, criminal law and legal education, and he's going to talk about the criminal law syllabus in Hong Kong and the realities of legal practice. Over to you, Professor Pascoe.
Thanks very much for the very kind introduction, Esther. Now, I'm going to share my screen so you can see my slides. Can everyone see my slides? Can you see my slides?
Yes, we can see them.
Okay,
sorry. Yeah.
Great. So let me get started then. This presentation's going to chime, I think, quite nicely with some of what Garen mentioned in his keynote lecture. So this is the title of my presentation. Now, in their edited collection, the book which is on the right hand of your screen, this was entitled The Teaching of Criminal Law, the Pedagogical Imperatives. One of Chris Gledhill and Ben Living's main arguments in their introductory chapter was that the criminal law syllabus doesn't adequately reflect the realities of criminal practice. And this view is far from new, but this view has inspired the research question or the first research question for this project. Basically, in Hong Kong, how can we align criminal law teaching syllabus more closely with the realities of practice in this jurisdiction? Now, criminal law syllabi throughout the common law world, including in Hong Kong, primarily focus on a few areas: homicide, lesser offences against the person, sexual offences, and property offences. And these are the crimes typically categorised as mala in se, meaning evil in and of themselves. And the explanation is typically, as far as I can tell, tradition. That's because these are the crimes that the syllabus has always focused on. Yet, as we know, this is not what legal practice in criminal law actually looks like, whether that's in the courts or whether that's in advising clients. So in his chapter that's simply entitled Choice, Chris Gledhill outlines an alternative approach that's open to legal educators. He suggests that criminal law lecturers ought to consider whether traffic offences and drug offences, which form a large part of the typical modern criminal lawyer's work, should play a more prominent role within the syllabus. And he stresses that legal educators have a choice. They have a choice whether to stick to the current system And they might do that because it has pedagogical advantages, including the greater availability of textbooks and the greater ability to hold the interests of students. Or they can switch. They can switch to a more practical approach, emphasizing closer connections with legal practice. Now, to myself, this kind of argument makes sense intuitively, but my aim here with this project was to ground it in some kind of empirical data. And there are at least two potential ambiguities within Gledhill and Living's argument that this research has sought to explore. First, as Gledhill notes, drugs and driving offences are far more numerous than homicides and sexual offences in most jurisdictions. That's obvious. But what he doesn't provide is any empirical sense of actually how do criminal lawyers spend their time, especially younger criminal lawyers. How do they spend their time in practice? So one of the things I aimed to do in this research was to assess how younger criminal lawyers spent their working hours. And the second ambiguity is that even if drugs and traffic offences occur at a greater incidence and consume more of lawyers' time in New Zealand, where Chris Gledhill teaches, or in England, where he practiced previously as a barrister, it doesn't necessarily follow that the same is true in Hong Kong. It's an open question whether drugs and traffic offences are as important or perhaps less important for legal practitioners here in Hong Kong. If they are less important in Hong Kong, is there perhaps a third group of offences, for example, departmental summonses or public order offences or organised crime, that takes up the balance of practitioners' time? So I aim to collect data to have a look at these questions. So let's go to the data collection. Now, the empirical component of the research combined some basic crime statistics from the Hong Kong Police Force website, together with a 7-page survey, which I sent by email and post to a cross-section of practitioners who worked in criminal law, at least on a part-time basis. The data reflected the period 2018 up to mid-2019, namely just immediately before the anti-extradition bill protests began in Hong Kong, and so I did that deliberately in order to convey what the criminal justice system would sort of normally look like in Hong Kong, although later I'll provide some observations on how the protest movement has affected criminal justice practice. So let's go to the data itself. So first of all, the police crime data. Now the police crime data broadly supports the contention that there's a mismatch between the content of the syllabus and the realities of life on the street, so to speak. So first, let's go to traffic enforcement in 2018. Apart from the fixed penalty notices, so in other jurisdictions they'd be called tickets, there were 1,030, you can see that in the bottom right of screen, 1,030 taxi-related offences that were dealt with by arrests or summonses. And on the left of screen, you can see at the bottom there were more than 18,000 other traffic offences that were dealt with by arrests and summonses, the vast majority of which, 85%, were for careless driving. And careless driving is an offence that is based upon negligence and carries a maximum of 6 months imprisonment and a fine of $5,000. So that's the traffic side of things. For non-traffic offences, here are the police statistics. There are 54,000 offences recorded in 2018, of which only 16% were violent crimes. The most prominent violent crimes were wounding and serious assaults. I've circled those. Now, of the violent offences, there were only 48 homicides in Hong Kong, 147 robberies, 63 rape cases. And by far the most prominent recorded crime by police, you can see 2/3 of the way down, were thefts. Okay, there were more than 21,000 thefts. There were also 8,300 or so crimes of deception, 4,800 or so crimes of criminal damage, excluding arson. So property offences, are predominant. And interestingly, I don't find that serious drug offences or indecent assault or triad-related crimes contributing largely to the totals in perhaps the way that I thought they would. Of course, there is a fairly detailed criminological literature on all the problems inherent in collecting and interpreting crime statistics. And the main conclusion, if you're not familiar with that literature, is that police records don't, of course, reveal the true extent of criminality, for which victim surveys are typically considered the most accurate measure. But in this project, I'm sort of less concerned with the extent of what we call hidden criminality. and I'm more concerned with the extent of reported criminality, because it's reported criminality that draws in legal practitioners as defence lawyers and as prosecutors. So that's the police force data. Now let's go to the survey data. So I basically distributed these 7-page surveys to all the practitioners on the Duty Lawyer Service list. And the Duty Lawyer Service, for those not in Hong Kong, is essentially a free legal representation service that covers first appearances in the magistrates' courts and also trials at the magistrates' court level. So the DLS list, well, unfortunately, only led to 23 responses out of more than sort of 1,100 lawyers, but I mean, that's kind of to be expected with busy practitioners. But I also distributed the survey further to colleagues of mine and also their practitioner contacts, leading to a further 7 responses. So I have 30 detailed survey responses in total, which I think is enough to make some basic observations from. And it's also important to note that not all of the respondents were practicing in criminal law 100% of the time. The average was about 60%. So these were typically practitioners who practice criminal law as well as some other areas of law. And this, I think, is important because most of our graduates at law school won't work in criminal law full time. So the survey, what it did was to ask practitioners, one of the things it did to rank the amount of time that they spent on and the number of cases that they worked on from 1 to 10 across these different offence categories. So 10 offence categories, and I'll go to the results. So this is how practitioners spent their time. In terms of the time spent and the number of cases, sort of combining these, the most prominent categories among the Hong Kong criminal lawyers were theft and other property offences, drug offences, and white-collar offences. On the other hand, the surveyed practitioners didn't deal very prominently with triad offences and, most noticeably, homicide offences. And the remaining 5 categories, the ones I haven't highlighted on the slides, occurred at medium levels of prevalence and were similarly ranked by practitioners. It's also significant that of the 30 responses, a third of them, 10 lawyers, chose to mention other areas of practice in their additional comments that weren't identified in the 10 that I provided. So the most common of these were regulatory offences, and I've provided some examples of their responses on the slide. Then let's go to what practitioners wish to see on the syllabus. So there are also questions about what practitioners wish to see on the syllabus, both structured and open-ended questions, in light of their own experiences, perhaps at law school and in practice. From the open-ended questions, these are a few of the trends, or these are my questions as well as a few of the trends. So 3/4 of the respondents believed that homicide and sexual offences were more likely to hold students' attention in class, particularly because of their sensationalist value in popular culture and the media. But they did not believe, on the whole, that these types of cases contain more legal issues, as opposed to evidential or procedural issues, or were superior repositories of actus reus and mens rea elements so as to aid teaching. Nevertheless, despite those observations, their opinions were fairly evenly split on whether driving and regulatory offences should be learned on the job as practitioners or else taught in law schools. One of the respondents, quite interestingly, noted that it was not necessary to include crimes merely for their sensationalist value, because the best teachers in law school can make what first appear to be dull areas actually very interesting to students. And I think this is an important observation. So that's some of the qualitative open-ended data. Now let's go to the quantitative data. Often the responses were sort of a little bit ambiguous here. One respondent often disagreed with the next, but of the clear trends of the 10 categories, there were 2 types of offences that respondents clearly felt did not need to be taught as part of the qualifying law degree in Hong Kong. And these were immigration offences and triad-related offences, although they didn't really explain why in their comment. For the other groups of offences, the responses were mixed, although there were noticeably more respondents who were happy excluding homicide and lesser offences against the person when compared with their own experience studying law during their qualifying law degree. Again, apart from the 10 categories I identified in the survey, Regulatory offences were mentioned several times in the respondents' further comments. A number of the respondents felt that it was important to study the offences that one would most commonly confront in practice, regulatory offences being the most prominent of those. But on this basis, we also had a high proportion of respondents who wanted 3 novel categories included in the syllabus because they came across them in practice. So these were the other highlighted ones. So white-collar offences, public order offences, driving offences. Now, the protests, right? So obviously the most important influence from the anti-extradition bill protests will be a big rise in the number of individuals who were tried for public order offences, criminal damage, and offences against the police, and therefore an increase in the amount of time that criminal practitioners spend on these crimes. This is reflected in the most recent police data from 2019 and also from several comments from my survey respondents. If, as a general principle, we want to align the subjects taught in the syllabus with what the criminal lawyer encounters in practice, then public order offences arguably should become a more prominent part of the Hong Kong law students' education. The question becomes, though, how long will these exceptional cases take to be processed through the system? And if the cases of the umbrella movement organisers are any guide, it could take up to 5 years, including appeals. Yet I think in designing the criminal law curriculum, we need to look at long-term trends and not just short-term trends. Also on this topic, we have the forthcoming national security legislation. So that provides another source of potential change. Although if the recent statements by the Secretary for Justice, Teresa Cheng, are to be believed, this law will only be used for the prosecutions of a relatively small number of individuals, albeit that those cases will retain crucial political importance and visibility, regardless of your views on the legislation. Let me go to my conclusion in the last minute or two. Now, the empirical data that I've outlined here is a tool that helps me to come to the conclusion that these are the offences that the criminal law syllabus in Hong Kong ought to include. And these are the offences which, in my view, sufficiently illustrate the main actus reus and mens rea elements, whilst at the same time are frequently enough encountered in criminal practice. So we've got property offences, particularly theft and deception, so as to teach dishonesty and intention. We've got lesser offences against the person to teach recklessness and result crimes and intention, causation rather, result crimes and causation. We've got drugs offences to teach knowledge and circumstances. We've got driving offences in particular to teach negligence. So I've mentioned careless driving and also dangerous driving. I think we can also use drink driving to teach states of affairs. We've got regulatory offences through which to teach strict and absolute liability as well as omissions, and I've mentioned some of the most common on the slide. And we've got white-collar offences, and particularly conspiracy to defraud and money laundering, which in their elements are a little bit different from the other property offences mentioned. So this sounds, pretty straightforward, I think. But what's more controversial is the list of offences which should not be included, despite these being taught in the past. So, to me, homicide and sexual offences are clearly not justified inclusions based on the police crime statistics and also the results of the survey, notwithstanding that, of course, most sexual offences are grossly underreported. More than one of the survey respondents mentioned that junior practitioners should be most concerned with summary and either way offences that are tried in the magistrates' courts, and they should leave the most serious offences such as murder, manslaughter, rape, holding for ransom for their later years in practice. The protest-related offences may in fact be deserving of their own elective subject, and if it were an elective, I suppose I could cover security offences, public order offences, offences against the police, criminal damage, and even the recently enacted offences involving COVID-19 social distancing. What are the surprising results from the empirical data? Well, the surprising results included the relative lack of interest among the survey respondents and the relative scarcity in the police data on triad offences, indecent assault, arson, robbery, and immigration. 5 areas which I had initially assumed would form a more prominent part of the criminal law practice in Hong Kong. And the final thing I'll say, just to wrap up, is for the international audience. So the aim of this study is not to mandate a particular sort of syllabus for other jurisdictions to follow, but rather just to share the method, okay, to help start a conversation on what a practice-oriented criminal law curriculum might actually look like. Similar work in other jurisdictions might provide expected, but also surprising results, as it's done here in Hong Kong. Thank you.
Thank you very much, Professor Pascoe. That was very, very interesting. And if it makes you feel any better, the low response rate in Hong Kong, it doesn't matter what field you're in, is something that is much more common. I remember somebody contacting over 500 schools for participation and ending up with 70 questionnaires. So that is, I think that's just an element of research in Hong Kong. I would like to remind the participants to please key their questions into me using the chat box. And whilst you are doing that, I'd love to ask you a question myself. And it's this. So a lot of the practitioners have said, well, you should keep those more serious offences or those more serious crimes for later years, and so you shouldn't put them in the syllabus now because it's irrelevant for people at the start of the career. But if you leave them out of the curriculum, does that not make it more difficult for the students once they start practicing to actually get higher up? Because it might be more intimidating for them to start doing something that they haven't learned about at all.
I think that could be, is my microphone on? Yeah, that could definitely be true. Although the respondents did indicate that it took more than, I mean, I've never practiced law in Hong Kong, I need to admit, but I've only taught here, but the respondents indicated that it took more than 10 years in order to gain enough experience before you could be left in charge of a murder case or a rape case in the High Court. The exception, though, I think where people can get experience in addressing jury trials seems to be in drug offences. And that's because drug offences occupy the majority of time in the High Court as far as criminal matters before a jury are concerned. So maybe that's one area where junior practitioners can get experience at making arguments before juries. The other thing I'll say on that briefly is that I suppose the new syllabus that I've suggested here is designed in such a way that all of the various constituent elements of criminal offences, including obviously intention, which is a large part of intention is a large part of the mens rea for homicide, and also knowledge, a large part of the mens rea for sexual offences. Those can be taught using other crimes. I don't think they're really missing out there. Those can be taught using other crimes that you will come across in practice in the early years.
Thank you. I do have some questions in the meantime. One from Luke Marsh, Professor Luke Marsh, who says and asks, the majority of students in a criminal law class do not go on to practice in this area. With that in mind, is there a great need to give so much focus on the caseload of local junior practitioners? If so, do you propose devising specialist teaching materials as textbooks are unlikely to cover more bespoke topics?
That's all? Sorry?
Yeah, that's it. That's a good, yeah.
Okay. I've got no plans to write a textbook right now, although I do note that there's nothing on drug litigation in Hong Kong. So that's a particular area which I think, given the prevalence in the High Court, that's a sort of glaring omission amongst the materials available to criminal law teachers. In terms of what the students are going to end up doing, yes, of course, most of them don't practice in criminal law, although they're allowed, even if their sort of day-to-day work isn't in criminal law, they're allowed to be on the DLS scheme. And in fact, most of the people that I heard from as part of the survey were from the DLS. So they're working in other areas. You know, they're working in commercial practice or employment or family law and so forth, and the criminal law practice, you know, is done on a part-time basis. And the final thing I want to say about that is that if our students come across criminal work in their early years, even if they're not working exclusively in criminal law, the most likely offences they are to come across are the regulatory crimes, and in particular the white-collar offences, particularly in a commercial setting. So I have included both of those in the proposed syllabus: regulatory offences and also the white-collar offences, namely conspiracy to defraud and money laundering. And I think more than one respondent mentioned that. Okay, said that this would be a useful way of balancing the two. You know, balancing the actual career directions of students with still the need to teach criminal law, which is the subject.
Thank you. I have a few more questions that came in, but also we are running out of time a little bit. So what I would suggest to the people who have asked these questions is that you contact Professor Pascoe individually. He has put his email address on the slides, but if not, his email can be quite easily obtained by typing his name into Google and following that with City University of Hong Kong, and you should be able to find him there. Thank you very much, Professor Pascoe, for a very interesting presentation, and we look forward to what the curriculum at CTU is going to entail.